to go into the beginning of deliberations to select a foreperson and go through some of those things before they can really then start going through the evidence. Typically jurors, and this is, not certainly a standard practice, but a lot of times what you'll hear from juries is that they may even take a quick poll at the beginning of their deliberations to find out where they stand on each of the verdicts off the bat before they start going through and looking at these things and discussing them. And they've got a lot here. There's 3 defendants. It's one trial, but it's essentially 3 trials simultaneously. So 3 verdict forms, 1 for each defendant. 2 of them are charged with 2 counts. That is Tu Tao and J. Alexander King. Thomas Lane has 1 count.
I always find it fascinating about how when jurors come together here, they're given basically no instructions about how to proceed. They have to self-organize and figure it out on their own, which is always very fascinating to me. Judge Magnuson did say this, though. I mean, they're charged with violating George Floyd's civil rights, especially with not offering medical assistance and failing to intervene. And he said a key word in their deliberations needs to be willfulness. Can you walk us through that, Rob?
Yeah, and that was addressed by all the attorneys yesterday in closing arguments. You've heard it through this trial, willfulness and deliberate indifference. And those are key. That is a key part of these charges because they are federal charges accusing them of violating constitutional rights against unreasonable search and seizure, against an unreasonable use of force, and the right to have medical aid if necessary, especially for those operating under the color of law. And what color of law means for constitutional rights cases is operating under the authority in some way, under a uniform or a badge, police officers or other officials that have some sort of authority over the general public, that they cannot abuse that authority that they're given and go beyond what the law allows them to do. So, that is your right against being unlawfully arrested or detained or unlawfully searched or a use of force that goes beyond what's reasonable for the resistance there, that once resistance ends, that force has to end. And so the willfulness is a key part of this. Did they willfully, knowingly, intentionally know that they had these civil rights, violations? Did they know that they had these constraints under the law or these duties under the law? Did they willfully do these things that they're accused of? Did they willfully ignore an unreasonable use of force and not intervene? Did they willfully ignore a need for medical aid and make that conscious decision not to provide that aid when it was necessary? So that's, again, a key part of this, that jurors really have to decide, did they ignore an unreasonable use of force or did they fail to intervene? You could say, yes, they failed to intervene, but did they do so knowingly, willfully make that conscious choice?
And that's a key point that all the defense attorneys made in this case is, how can you willfully violate the civil rights when you don't perceive that there was a problem to begin with? And in the case of J. Alexander King, his attorney tried arguing that he couldn't even see Derek Chauvin's knee on George Floyd's neck.
Yeah, and that was a key part of when he took the stand in his own defense, that he could not always fully see, even though, as the prosecution pointed out to jurors, he was shoulder to shoulder with Derek Chauvin. Under his testimony with his defense attorney, they tried to make it clear here that he couldn't necessarily completely see where his knee was. That in training, the defense attorneys pointed out there's lots of training that shows knees on necks or at the base of the neck, certainly at the top of the back, to hold people down. And so they wanted to kind of put that doubt in the jurors' minds here, that he could specifically see that it was on his neck in such a way that would cut off his ability to breathe. So did he willfully ignore that? Well, under cross-examination, J. Alexander King said, well, you have to perceive that the use of force has gone too far in order to then intervene in that use of force. It's your perception of it.
And which leads to an interesting concept that was brought up over and over again during this trial, and that is the concept of excited delirium. This is a diagnosis that is not accepted by the American Medical Association, but yet it is still taught to police officers as a condition. And in this case, the officers testified that they kept restraining George Floyd even as it appeared that he lost consciousness, because they did not know if he would suddenly regain consciousness and overpower them. Correct?
Yeah. And so much of this case for the prosecution and the defense is focused on training. The prosecution really thoroughly going over the idea that officers were trained that once somebody is restrained, you put them on their side so that they can breathe, and that if they don't have a pulse, you immediately give CPR. And the defense then really making the case for jurors that the training shows that, especially for cases of suspected excited delirium, this agitated state, that the training shows that you hold them down until EMS arrives. And that training often showed knees on the neck or the base of the neck, so that they were arguing they were doing as they were trained. As the prosecution argues, they were not doing as they were trained. So it's this kind of fog that the jurors have to go through. Were they following the training, as the defense says, or were they ignoring the training, as the prosecution says? Again, they're saying that in suspected excited delirium cases, they believe that's what the training is to continue to hold them down. That's what Derek Chauvin said, and you heard that on the body camera videos, is that's why we got him, face down or stomach down, and we're going to hold him here until the ambulance gets here. So again, were they ignoring their training, or were they following the training? And that is part of the willfulness, that they've got to look into.
Now, Amanda Sertich, who was the prosecutor from the U.S. Attorney's Office who gave the closing arguments yesterday in court, she begged the viewers to refer to what she called the two simplest things in this case. Number one, the video, and number two, their own common sense.
Yeah, and she said it really got simple in that sense, although her closing argument went an hour and 40 minutes, so it was very complex and complicated as she walked through it, but then ultimately it's simple. Look at the video and use your common sense. And the prosecution, very much a key element of their case to jurors are the bystanders on the sidewalk. And, this came up repeatedly through this case. And then it came up in their closing arguments that here are a collection of 8 people on a sidewalk, some of them teenagers, who are saying, he can't breathe, take your knee off his neck, he can't breathe, who are saying, as he goes unconscious, he's not moving, why are you still restraining him? Check his pulse, is he still breathing? If not, they were saying these things. And so the prosecution saying, if they saw this, untrained observers, and again, teenagers, some of them, that the officers then should very well have seen the same thing. Certainly if they're hearing this coming from the bystanders, if they're not recognizing it themselves, that should key them in to recognize it and look for these things. So that is key for them. That that is the common sense involved here. But again, the defense doing a pretty good job at putting some doubt in that Alexander King didn't fully accurately see where the neck was. Did he hear the bystanders? And he said, well, I heard them talking and heard noise, but he was so focused that he didn't hear those specific observations or pleas, so therefore he wouldn't react to that. So again, that's part of what the jurors have to wade through here is, the common sense of an observer, and then the experience, as one of the defense attorneys said yesterday, and that was King's attorney, what did he see and experience in his moment from his vantage point where he is? And the same thing with Thomas Lane's attorney saying, that that if Derek Chauvin, the senior officer here, is telling them, no, we're going to hold him where he is, that they have then a trust in that he is making the right decision here, and that he must have a better sense of this than they do. That this is okay to continue to hold him face down and to not respond to some of these concerns about breathing. That he must know what's going on.
Rob, let's talk about those jurors here for a moment. 12, of course, on the jury. They've been looking at the evidence in this case now for almost 3 hours. We have no idea, of course, how long they're going to take. But we're talking about individuals that come from all over the state of Minnesota, not just necessarily Hennepin County or Ramsey County.
Yeah, and that's because this is a federal trial. So instead of a district court, which is a county-based court that draws jurors from a county, Derek Chauvin's murder trial, they're all from Hennepin County. The federal court draws from a wider pool, and in this case, it's sort of the Twin Cities sort of region, and then a little bit beyond that. So they put out jury summons. They're randomly sent out. They bring in these pools, and so what they wound up with here is 8 women and 4 men, and they are 2 each from Ramsey, Olmsted, and Hennepin counties, and then 1 each from Anoka, Washington, Scott, Nicollet, Blue Earth, and Jackson County. Jackson being the furthest away for any of these jurors, but so they come from a wider area. They are all white in this case, and that is a contention for activists and observers watching this trial, that this is an all-white jury. But again, that comes from casting this wider jury summons to other counties. And these are the jurors that got those summons and came in. There were some people of color in there in the pool, but who did not wind up on the jury. There were several people that appear to be of Asian descent. One of them is an alternate in this case, and that's it. The 12 that are now deliberating are all white. Again, 8 women and 4 men.
And Rob, is it your understanding that because all 3 of these former officers are charged together, that their verdicts will be read together as well? In other words, let me clarify here. They're not going to, if they reach a verdict on one officer, they're not going to announce and then go back to the jury room and work on the other 2. They're going to do this all at the same time. That's my understanding, at least.
That's my understanding as well, even though this is 3 trials held together as one trial. They are 3 separate defendants, so there is a verdict form for each of the 3 defendants. But my understanding is they don't deliberate on one and come back and announce that verdict. They do it all and come back and announce the verdicts all at the same time. I mean, if we get information that it's going to be done differently, I'll certainly let you know. But at this point, that is the understanding, that it is done that way.
And Rob, do we know if this stretches into the weekend? Do we know if the jury will be sequestered or not?
We do not know that yet. The judge did not indicate whether he would sequester this jury, so we don't know. We don't know if that's a decision that he is going to, if he chooses to make that at a later time, if he's able to do that. The federal court rules are certainly a little bit more different than the district court rules. So, but at this point, we have not had any indication. We've not heard anything to say that they will be sequestered.
All right, standing by to stand by, as we like to say in our business. Again, the jury at it for just about 3 hours. They went into deliberations shortly after 10 o'clock this morning. Rob, thanks so much for being there for us once again. And we just want to remind our viewers here on the stream that we will have immediate updates on fox9.com, so check in there. And we will also bring you updates here when we know that there is a verdict coming down the pike. So we'll keep you informed. In the meantime, I'm Tim Blotz on behalf of all of us here at Fox 9 in Minneapolis. Thanks for joining us, and we'll see you tonight on the broadcast starting at 5 o'clock here on Fox 9. And of course, if we know anything else, fox9.com, and we'll break into here at the stream here too at fox9.com/live and on our YouTube channel as well. Have a great afternoon, everyone.